The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. The next case is in re GB, MB, and A.O.J. And we will hear from the appellant.
Thank you, Mr. Chief Justice, Associate Justices. May it please the court, my name is Sean Vitrano. I represent the respondent father, Stephen Bullock, in this TPR appeal. My colleague, Robert Ewing, represents the respondent mother. We anticipate that we're going to split our time. I'm going to speak for about 15 minutes or so on grounds today. Mr. Ewing will then speak about best interest for about 10 minutes, and we'll reserve the last 5 minutes of our time for rebuttal, please. Stephen asked this court to reverse an order terminating his parental rights to his minor children, Mark and Gail. The trial court found grounds to terminate for willfully leaving the children in foster care for more than 12 months without making reasonable progress in correcting the conditions that led to removal, for neglect, and for non-support. And unless the court has something different in mind, I'm going to address the grounds in that order. The issue in this case is whether the trial court's factual findings were sufficient to support its conclusions that all three grounds existed. Stephen was incarcerated when the children came into Wake County's custody and when they were adjudicated, neglected, and abused. He remained in prison at the time of the TPR hearing in June 2019. During the course of this case, he was housed at 5 different institutions. But when the TPR hearing concluded, he was only 1 month away from his release. And while Stephen was in prison, he entered into a case plan that was adopted by the trial court. That case plan had the following components. He was required to establish legal paternity of his son, Mark. He was required to complete a substance abuse assessment and a mental health assessment and comply with recommendations. He was ordered to submit to random drug screens, and he was ordered to obtain and maintain safe, stable housing and lawful income sufficient for his family. Stephen complied with the case plan in several respects, which we think is relevant to both reasonable progress and grounds. So I want to focus on those facts a little bit. Stephen established legal paternity of Mark. That was the first condition that he needed to comply with, and the trial court in this case, in its TPR order, found that he had done so. That is the only component of the case plan that the trial court explicitly acknowledged. With respect to the drug component, Stephen had a substance abuse assessment in March of 2018. At that time, he was diagnosed with a cannabis use disorder, severe, in sustained remission, because he'd been incarcerated since November 2016. The assessment recommended that he participate in random drug screens, which was already a component of his case plan, and that he be given contact information for 4 community organizations that could eventually provide him with services. Stephen couldn't obviously do any of the community-based programs because of the fact of his incarceration. There was one organization, Day-to-Day Dads, that had a program at Franklin Correctional Center that Stephen was moved before he was able to participate and receive services from them. Stephen got 3 drug tests while he was at Franklin Correctional. All of those were negative, according to his testimony. He testified that he attended NA meetings for over a year, and those were weekly meetings. He testified that he repeatedly requested drug screens from the staff at the institutions where he was housed. And in fact, when he was housed at Birdie Correctional Institution, he staged a protest until a supervisor relented and gave him a test. That test, the results of it were introduced at the TPR hearing into evidence. It was a negative drug screen taken 3 days before the June 6th hearing. With respect to the mental health component of his case plan, there was no showing that Stephen had an ability to comply. Wake County originally sent a doctor out to Franklin Correctional, but he was not able to get into the facility. Wake County didn't attempt to send anybody to Mountain View where Stephen was housed because they believed that he couldn't have visits when he was in isolation. A social worker eventually asked Avery County to complete a psychological evaluation, but there was no follow-up on that, so we don't know that that was possible, and of course, there was no evidence that it occurred. But a parent has to have an ability to comply with a case plan for the court to find that the parent didn't make reasonable progress. And here, Stephen didn't really have an ability to get the mental health assessment. Similarly, with respect to the housing and employment components of the case plan, it's very difficult to say that Stephen didn't comply because he was incarcerated throughout the pendency of this entire case. His testimony, however, was that he had a plan for both. The trial court knew that his release was imminent. Stephen's father came to the TPR hearing and testified that he had secured Stephen a private room in a shared apartment on a month-to-month lease. Housing was never a problem for Stephen before his incarceration. In fact, the petitions alleged that when he knew he was incarcerated, he arranged for money to be left for the mother and the children so that they could use it towards rent and their expenses. On the employment side of this, Stephen's father testified that he had arranged a job for Stephen for $12 an hour working for a man that had also employed Stephen's brother. And Stephen had a pretty solid work history before incarceration. He had worked for a restaurant, he had worked at a moving company. This is not a person that had a history of unemployment. Moreover, while Stephen was incarcerated, he was working very hard to acquire vocational skills that would serve him when he was released. The testimony that was undisputed was that he earned his high school diploma, he earned his HVAC certification, and he earned a state license. At Franklin, I think it might have been at Wake, he was enrolled in an electrical wiring class. At Birdie, he had signed up for a computer class. Stephen's goal the whole time that he was incarcerated was to acquire as many vocational skills as he could so that he could be in the best possible position to obtain employment upon his release. And he also testified that upon his release, he had a plan to attend school for truck driving and to become certified as a heavy equipment operator. Taken together, we think that those facts show reasonable progress on the case plan, contrary to the court's ultimate conclusion. Stephen simply wasn't a father who willfully left his children in foster care for more than 12 months.
What standard of review are you contending that we should apply here then based upon what you're representing?
The standard of review, Justice Morgan, in a TPR case is, of course, whether the court's factual findings, the trial court's factual findings are supported by clear, cogent, and convincing evidence, and whether those findings support its conclusions of law. And what we're arguing here is that the findings that the trial court made did not support its ultimate conclusion that Stephen didn't comply with his case plan or that there was a likelihood of future neglect if the children were returned to his custody.
And is that because of the fact primarily that you're saying that the DSS did not do enough in light of the fact that your client was incarcerated for most of the period of time that's relevant here?
I think, well, what I'm saying is essentially a few things. DSS, Stephen can only be required to comply with those components of a case plan that he had the ability to comply with. And because of the fact of the incarceration and the nature of the incarceration, where he was housed and what programs he had access to, he couldn't do all of the things that were required of him.
So how should that be evaluated in circumstances where, on one hand, his case plan orders from the trial court that he complete those, but yet he is not in a position to do that? Is that to be held against the DSS because the father is not in position to do that which the court has ordered him to do?
It's not, Your Honor, that it's to be held against DSS. It's that the father's conduct in this case can be excused. Just last month,
Mr. Petrano, I'm understanding, and I got this argument out of your brief too. I think you seem to be saying that what we should do is look at the case plan, look at what the father did, and then in essence told that since, in your view, he did everything he reasonably could do under the case plan, the findings don't support the conclusion of neglect or failure to make progress. If I'm reading the order correctly, it appears that the trial court said, in essence, that the real reason that your client should be subject to termination on the ground of neglect and failure to make progress is that he did a number of things that substantially prolonged his incarceration, i.e. getting convicted of having contraband cell phone in the prison and committing various and sundry violations and failing to take jobs that would have shortened his period of incarceration. And that therefore, because instead of doing everything he could to shorten his period of incarceration, therefore comply with his case plan and reunite with the children, he did the opposite. And that because of that fact, he should be found to be subject to termination. His rights should be subject to termination on the ground of neglect and termination of his rights. I guess my questions are, first, do you agree that that's what the trial court's order does? And secondly, assuming that you agree that that's what the trial court's order does, why is that an inappropriate way to analyze the neglect and failure to make progress issue?
Thank you, Justice Ervin. I appreciate that question. I agree that the facts that the court considered, which are laid out pretty clearly in paragraphs 32 to 36 and 38 to 41, as they relate to neglect and reasonable progress, are these: that he was convicted for illegally possessing the cell phone, and that extended his time in prison for 16 months. That he quit his job at the sign factory, which caused him to lose his earned time credits. And that he had repeated disciplinary infractions, which limited his ability to do classes and to earn earned time credits. The trial court was certainly within its rights to be looking at those factors and considering what he did while he was incarcerated. Obviously, the case law is very clear that the fact of incarceration alone can't be used as a sword against him, but his behavior and his
or a sword or a shield.
Correct, Your Honor, absolutely. But in this case, so the court was absolutely focused on the behavior, but the court completely ignored all of the evidence that, in spite of those conditions that Stephen created for himself, he still managed to make more than minimal progress, certainly reasonable progress for the things that he could. And in addition to that, I mean, this was not a...
Hold on just a second. I'm afraid I'll not be following your argument if I don't ask this question.
Mm-hmm.
So you're not contending then that the trial court erred by looking at the father's behavior in prison. You are contending, in essence, that it overweighted the father's behavior in prison vis-a-vis the father's degree of compliance with the case plan given his imprisonment?
I would, yes, Your Honor. I would say that the trial court, I don't want to use the word overweighted because the weight to be given to the evidence is really within the purview of the trial court. But what I guess the way I would describe it is that these facts, these things that he did that unfortunately prolonged his time behind bars, weren't sufficient to show that he wasn't making progress on the case plan, that he willfully left these kids in foster care for 12 months, or that there was going to be a likely repetition of neglect.
Does the trial court get to decide whether there was too much emphasis? I'm trying not to use weight for the reason you said. Your point's valid.
Right.
Does the trial court get to decide how much emphasis is put on one set of factors as compared to the other, or is that something that we're entitled to look at on a de novo basis on the field?
Well, the trial court gets to decide how much weight to give the different evidence, to give the evidence in front of it, Your Honor, but the trial court doesn't get to ignore wholesale evidence of compliance or other facts which would mitigate the findings that it made here. So, for example, emphasizing the fact that he quit the job at the sign plant and therefore lost earned time credits, which would have reduced his sentence, that's not quite a fair representation of what Stephen was trying to do. Stephen's emphasis, and he testified at length about this, was that he was trying to get vocational education as much as he could absorb so that he was in a position to obtain lawful employment upon his release.
Is the trial court obligated to treat that? First of all, is the trial court obligated to accept his testimony on that point as credible? And secondly, one way or the other, does the trial court get to decide how much weight to give that explanation or how much credence to give that explanation, or is that a matter for this court on appellate review?
Well, the trial court gets to decide how much weight to give to the testimony of the witnesses, but here the trial court needs to make factual findings if it's finding his testimony to be incredible. And here, the trial court didn't do that, and that testimony, quite frankly, was undisputed. So when Stephen is making, when he was giving testimony that the reason that he got the cell phone was because he learned of the abuse of Mark after the petition was served, there was really nothing to undermine that testimony. Similarly, when he was saying that his focus and the reason that he made the decisions that he did was because he wanted to position himself for employment at the end, there's nothing in this record that this, that would discount that testimony.
Okay, thank you.
I think that I'm at 15 minutes, so I'm gonna yield to Mr. Ewing unless the court has further questions.
May it please the court. My name is Robert Ewing, and I am an attorney out of Forsyth County. I represent the respondent mother, Sally. I am using the pseudonyms that we agreed to in the record for the parents and the children so in order to protect their identities. There is one issue that has been raised by the respondent mother in her appeal. The trial court in this instance should reverse the termination order because it was not in the best interest of the children to terminate parental rights. There are two reasons why we argue that it was improper. One, termination of parental rights will detrimentally impact the children and permanently cut the children off from their mother and maternal relatives. And the second reason is because termination is actually preventing the children from being placed in a safe, permanent home within a reasonable period of time. Now, I do need to address to the court about the standard of review. In December of 2019, when I wrote my brief, I, in good faith, argued that this court should use a de novo standard of review in determining best interest. However, since that time, this court has issued opinions. I have supplemented those cases in my memorandum of additional authority, which have held that best interest is determined under an abuse of discretion standard. Regardless of what standard that we use, this court should still reverse the termination order. When we look at the purposes of the juvenile code, and they seem to be discussed in a few of the cases, A.O.J was the most recent case that I had seen. The purposes of the juvenile code set forth kind of goals for the court to use when deciding how to deal with juveniles and the parental rights. One of the goals in 7B, the goals are set out in 7B 100, but subsection 4 is one of the purposes is to prevent the unnecessary separation of the children from their family. Also in 7B 100 subsection 5, also one of the goals is to put the children in a safe permanent home if they can't be returned to the parents. So those are kind of the two factors I know that this court has looked at in A.O.J and I know in ZAM, I believe. So those are kind of the factors, overriding factors you're looking at. In this instance, both of those goals were thwarted when the court terminated parental rights. The reason why is because termination of parental rights permanently severed the relationship of the children from their parents on the maternal side of the family, and there was a home available for the kids to go to shortly after the termination hearing. To help the court decide whether termination is the best interest of the children, the legislature enacted 7B1110A, which set forth several factors that a court is required to make written findings of fact and criteria concerning things that are relevant. In this case, the court abused its discretion when it made to make findings of facts concerning the quality of the relationship between the children and the maternal grandmother and the maternal aunt. Both of those relatives were placement options for these children. If the court looks at 7B1110A subsection 5, the court is required to determine the quality of the relationship between the juvenile and the proposed adoptive parent, guardian, custodian, or other permanent placement. Both the maternal grandmother and the maternal aunt were permanent placement options in this case. However, in its termination order, the court failed to make any findings about the quality of that relationship. It is very significant for this court to know that the testimony provided at the termination hearing, the guardian ad litem for the children testified that Anne, who's the 15-year-old daughter, would have a very difficult time with terminating parental rights. Also, the 5-year-old Mark, there was a testimony that he might need therapy or counseling to deal with the issue if termination of parental rights occurred. The reason why these kids were so bonded with the maternal relatives is because maternal relatives had stayed in contact with the kids the entire time. When this case initially started, after about a month in the case, Mark and Gail, two of the younger children, were placed with the maternal grandmother in November 2017. The children lived there until January of 2018, when unfortunately maternal grandmother had a diagnosis of cancer. At that time, it was agreed, the maternal grandmother had to go to the hospital at Duke University for a month, and it took some time to recover. So they agreed that it was to be placed to place Mark and Gail in foster care. I would like to note that the court noted in February of 2018, after the children were moved, that the children were doing well in the care of the maternal grandmother. However, despite the cancer diagnosis and the placement of the children in foster care, the maternal relatives continued their connections to the children. The respondent mother, my client, had visitation with the kids. The maternal grandmother maintained contact through calls and visitations. And the maternal aunt expressed that the maternal aunt also had visitations, sometimes weekend visitations. She held birthday parties for the children, provided them with clothing. At the termination hearing in June of 2019, the grandmother last saw Mark and Gail at a T-ball game 2 weeks prior to the termination proceeding. Throughout the duration of the case, the maternal relatives have maintained contact. The children wish to maintain contact. But the second part of this case, and I know I'm limited on time, is finding of fact number 81. The trial court found that my client did not have adequate space in her home for the children or finances to provide a stable home. That was not supported by the evidence at the time of the termination hearing. Please note that on February 28th, at a permanency planning hearing, the grandmother reported that she was in remission from her cancer. She reiterated that at the termination hearing, and she further stated that she was under no restrictions. The maternal grandmother also informed the court that she's entering into a lease where she'll be moving into a 3-bedroom, 2-bathroom apartment to provide sufficient room for the children. She also testified that she caught up with her medical expenses, so she's no longer under financial difficulty. The grandmother is employed. She's at rest care. Also, a new fact that came in is that she received additional income through her retirement. Now, at the February 28th permanency planning hearing, the court found that she didn't have the finances to support the children. However, that situation has changed. The grandmother has placed herself in a position to get custody of these children. I do want to note that the further abuse of discretion in finding of fact number 81 during the rendition of the judgment after the termination, after the evidence was presented, the court found, and this is what quoted, as for the court's finding in February of this year is that the grandmother was not in a position or wanted to care for the children but was not able to meet that prong. The court based that finding on fact based on the evidence back in February and not at the current time. The situation has changed. These children want to be with their maternal relatives. Termination of parental rights is not in the best interest of these children because it'll cut off their relationship with the maternal side of the family. And number two, the maternal grandmother has placed herself in a position to take custody of these children.
Let me ask you about the factors that determine the best interest of the children. As I understand it, they're set forth in the statute, and this order seems to sort of track those. And one of the things that you didn't mention, but that the trial court seems to have acknowledged that the young boy, I think you call him Mark,
yes.
Had a strong bond with his mother, but also now I'm looking at finding 74 and 75. Seemed to be quite concerned about her relationship ongoing with the Mr. Galloway.
Yes.
The little boy seemed to be pretty distressed about that situation. So my question is, isn't that something that's appropriate for the trial court to take into consideration in evaluating the best interest of the child?
Absolutely it is, and it should be taken into consideration. But our argument is that, and even the mother is that if you couldn't have custody of the children, either her mother or the kid's aunt should have custody. And there's been no issue with the grandmother with her care. There's been no issue that she's not able, to follow orders. And in fact, she had the kids for 3 months and she had the diagnosis of cancer. So that was in existence even back then when she had the kids.
Well, the trial court sort of sums it up in the finding to the effect that there was a problem with them having ability to provide a stable home, even though the trial court seemed to acknowledge that there were efforts and bonds. And why isn't that an appropriate?
It is appropriate, but I would tell you, finding of fact number 81, I don't think it's supported by the evidence. Things have changed. There was a permanency planning hearing in February of 2019. At that time, the grandmother reported major medical bills from Duke University and other places. So she wasn't financially stable at that time. However, since she testified she caught up on her finances, that she's back to work. She's doing the things to place her position. And in fact, she said she was ready to take the kids and was getting ready to enter into a lease for a new residence. So I don't believe that finding is supported by the evidence. That would be my argument. And in the rendition of the judgment, I will tell you the court focused back to then and not till the time of the termination here. I just asked the court to look at that. Are there any other questions? I know I've cut into most of my time. We just leave the remainder for rebuttal.
That sounds good, counsel. Thank you so much. We'll hear from the appellee.
I'm sorry. Good afternoon, Chief Justice Newby and Associate Justices. May it please the court, my name is Mary Boyce Wells and I represent Wake County Human Services. Mr. O'Rourke and I will be splitting our time. I'll have 20 minutes and he'll have 10. I'll be addressing the grounds for termination of parental rights and he'll be addressing the best interest determination. Based on counsel's argument, I think I'm going to go right into the fact that I believe that the evidence is clear that that the father in this case is using his incarceration as a sword. I think it's important to review exactly how we got to the adjudication hearing and then what happened from the time of the adjudication hearing until the termination hearing. Prior to his incarceration in November 2016, the father was living with the mother and the children. He had 2 prior felony convictions and he was on felony probation. He made the determination to sell drugs in order to make more money. As a result, he was arrested, charged with a drug offense, and sentenced to prison in November 2016, leaving the mother to care for the children. After he was incarcerated, the mother took up a relationship with Mr. Galloway that was very tumultuous. There was substance abuse, domestic violence, and physical abuse. The 3-year-old child was found to have bruises, black eyes, and a broken arm within a short period of time. Wake County Human Services became involved in October of 2017, and we took custody of these children. There was an adjudication hearing in November 2017. Mr. Bullock appeared at the hearing and he admitted and consented that his children were neglected and that Mark had been abused. At the time of the adjudication hearing, Mr. Bullock had 3 months left on his sentence. He was due to be released in March 2018. He was housed at Wake Correctional Center, which is a minimum custody facility. It's in Wake County, where Mr. Bullock resided, where the children resided, where the mother resided. He had the ability at that time to just follow the rules of incarceration for 3 months. The best thing he could have done for his children was to get out of prison. Then he could have started his case plan, got a substance abuse assessment, and followed through with the requirements and reunified with his children. And again, he was in Wake in a minimum correctional facility. The social worker was in Wake, the mental health assessor was in Wake, his family was in Wake, and he only had 3 months left on his sentence. Instead of doing that, he decided to illegally possess a cell phone. He was charged with a felony. And in December 2017, less than a month after the adjudication hearing, he received an additional sentence of 11 to 23 months incarceration. Which now
I'm sorry to interrupt you, but I want to be understand your position with regard to, first of all, you said that he consented that the children needed to go into care, but he didn't admit at that point that he had anything to do himself with the conditions that led to them needing to be taken into care, right?
Well, I disagree with that. I think he admitted that his children were neglected. And I believe that because that he was incarcerated on his own willful conduct, that he left his children. The court
but isn't everyone incarcerated based on their own willful conduct? And wouldn't this lead to a rule that there is automatically neglect for anyone who is convicted and receives an active sentence?
Well, I think it depends on the circumstances, but the court has held that there's no requirement that the parent who is subject to a termination of rights on neglect be responsible for the neglect at the time of the adjudication hearing.
All right, but I'm first just trying to be clear that he was not personally involved in the circumstances that led to the children being taken and being neglected in the first instance. He was in custody at that time.
And I think my position is that had he not willfully been incarcerated, he would have been available to care for the children, and they would not have had to go into foster care.
But that is true for everyone who's incarcerated, right?
But I think the court has addressed that issue. And in JMJJ, I'm sorry, in June 2020, this court stated that they did not agree with respondents' claim that he played no part in the prior adjudication of neglect. Although he had no role in the mother's substance abuse and mental health issues, the child's removal from the mother's home and resulting placement in foster care were also due to the fact that juvenile could not be placed with respondent. So I think the court has addressed that issue. So
by that logic, then every person who is convicted and sentenced to active time by operation of law has neglected their child. and is subject to termination of parental rights based on neglect.
Well, no, I think there has to be an adjudication of neglect before you can proceed to the next prong and determine at the time of the termination hearing, have the conditions changed since there was an adjudication of neglect.
Well, and I want to also ask, I didn't mean to cut you off if there was more that you wanted to answer.
No, that's fine. Thank you.
But I do also want to ask about your view of the issue of his possessing the cell phone and his testimony and his evidence that he felt the need to be able to communicate because of what had happened to his children. In your view, does it matter? Because as I understand your argument, the fact that he voluntarily decided to break the rules and possess a cell phone is why he is therefore responsible for continuing to be in custody. And I guess my question is, does it matter why he possessed the cell phone? Because while it is breaking the rules, if he feels it's necessary in order to maintain contact with his children and to try to look after their well-being as best he can where he is, shouldn't that also be a part of the consideration?
I have a two-part answer to that. First, I think if you commit a crime and you know you're going to commit a crime, that you need to be held responsible for that. My second part of that answer is I think his testimony is not credible. The children at the time were ages 14 months and 4 years old. There were legal ways to contact his children and keep in touch with them. He could have money in his account and make phone calls. He was also housed at the time he had the cell phone in Wake Correctional. He was allowed to have visitation. They could have visited him. And I think with children that young, 14 months and 4 years of age, it would have been more beneficial to meet with him in person. Or I would even argue that I think he should have waived the consequences. He only had 3 months left on his sentence. He had the ability to get out in 3 months and do his case plan, and his children would have only been in custody 4 months at that time. But by choosing to commit a crime and then having 11 to 23 months tacked onto his sentence, where he extended the time that he was separated from his children, I don't think that he made a very good decision. And I just don't think his testimony was credible.
But the question that the trial court had to ultimately decide is whether or not there were grounds to terminate his parental rights based on the course of events. And the consequences of possessing a cell phone while in custody, there's no law that says the consequences of that are that you should lose your parental rights. So we have to go back to what the grounds were that the court should examine. And I kind of interrupted you as you were starting to talk about those, but it does seem that I guess I would like to hear more clarity from you, or I'd like to hear more about not just the bad things he did, but how it is that he was able to comply with his case plan and failed to do so.
Well, I think I can summarize, if I can just briefly summarize from the time that he was adjudicated until the time of the termination, what exactly he did while he was incarcerated. And I think if I do that, it'll give you a picture of how I believe that he did not make willful progress. He did not comply with his case plan. And in fact, he regressed. At the time of the adjudication hearing in 2017, he was housed at a minimum security facility in Wake County. He had the ability to meet with his mental health assessor, his social worker. Following that, he picked up a new felony charge of having a cell phone. He quit a job which would have allowed him to have game time and make money that he could provide to his children for support. He quit that because he simply did not want to work, is what he testified at the court hearing. After that, he was transferred to a facility where he was placed in lockdown because he was associated as a gang member. After he left that, he went to Avery Mitchell, where shortly after he arrived, he was involved and charged with 3 infractions where he was placed in the hole for 20 days. Shortly after he got out of the hole there, he received infractions for assaulting staff, and he was replaced in the hole for 50 days. His social worker testified that she went to visit him and met with the case manager, and he told them that he was not going to stop disobeying the rules of prison and stop committing infractions unless it added to his length of incarceration. He continued to get tattoos after he was placed in the hole for doing that, and he continued to do that throughout his stay. We tried to get a social worker from Avery County to go help him with a psychological assessment and programs. And she did that and reported back to the social worker in Wake County that because he was in isolation due to his infractions, he was not able to complete that. After he left that facility, he went to Bertie County. Shortly after getting there, he was involved in a gang fight where he was stabbed. And he was subsequently placed in isolation, which is called ICON, where he was locked down for 23 hours per day, only allowed 1 hour out, and he was not allowed visitors or phone calls. So we have a situation in the period of time from adjudication, he went from a minimum custody facility to the time of the termination hearing, he was in 23-hour lockdown with no visitors and no ability to make phone calls. Those were all due to his own willful conduct. His continuing to get tattoos and commit criminal offenses. In regards to his case plan, he did get a substance abuse assessment, and he told the assessor that he had smoked marijuana every day since he was 17 until he got incarcerated. He testified at the hearing that he was clean for 18 months, but he had been incarcerated for 30 months. He didn't get a mental health assessment because he was in isolation, and there was no way Dr. Aiello or anyone else could go in to see him. He testified that he tried to keep in contact with his kids with telephones and cards and letters. And at the hearing, he said he talked to them in the past 2 years 10 times over the telephone. In regards to the cards and letters, the social worker indicated that he sent them when he was not in isolation. And at the termination hearing, she testified that he had sent the children 3 letters and 1 card in the 2 years that he was incarcerated. He was not allowed gain time, and so because he quit working, so his maximum release date was pushed back into July 2019. And all of those things were based on his conduct. Is our position that he did not comply with his case plan. The only thing that he did do, he did complete an affidavit of parentage for Mark, which the only thing he had to do for that was sign an affidavit. And had he been in a minimum facility or another facility, he could have had random drug screens, hair screens. He could have substantially completed his plan, but due to his own unlawful, willful behavior, he was in the position he was in at the termination hearing. He testified at the termination hearing that he didn't have any plan for housing. He hoped to have a house within 5 months. His father testified he had a 1-bedroom, but it wasn't suitable for the children. He had no plan for a job. He testified that he wanted to go to Wake Tech and do 7 weeks of some type of school, which would not have enabled him to provide any support or care for his children. So he didn't have a plan, and it's our position he did not make reasonable progress, and that based on his behavior, that before and after the adjudication hearing, obtaining a new felony conviction while incarcerated, it's our position that if he was unable to follow the rules while he was supervised and incarcerated, it's highly likely that when he's released and he's free, he's going to be worse than he was when he was incarcerated. And I think the court looked at that, and they based their findings of fact and conclusions of law supported the fact that his criminal behavior made it likely that he would continue that upon release. And these children, when he went to jail, I think Gail was 4 months old and Mark may have been 13 months old. And he had not been in their presence for almost 32 months, I believe it was, since he went to prison. And the lengthy incarceration, we say, was due to his own willful conduct. There was also evidence that he failed to pay a reasonable portion of the cost of care of the children in the 6 months preceding the motion being filed. And we believe the findings of fact and conclusions of law cover the fact that he was physically able to work while he was in prison, and he had the ability to make money while he worked, that he could have contributed. And they even discussed the fact that it may not have been lucrative, but it would have been at least something to provide to the cost of care for the children, but that he failed to do that.
As I understand his argument on that point, he's saying that during the operative period, during the operative 6-month period, there was not evidence in the record that he was at a facility that actually had a job that he could do.
Actually, there was testimony that he was at Bunn Correctional Institute in December 2018. He testified that he worked in the kitchen for 2 weeks, but that he was placed in isolation, so he lost his job in the kitchen. So I would submit that that was within the 6-month time frame before the motion was filed. I also think the findings of fact were pretty, it said that he had the physical ability to work while he was incarcerated. And had he worked, he would have been able to earn some money. They also, it was a finding that had he kept his job in the sign plant, he would have been, and earned gain time, he would have been released in February 2019, which was in that 6-month time period. And he would have been able to pay from his work at the sign plant. So it is our position that we believe that the findings of fact regarding willful failure to pay in the 6 month immediately preceding the filing the motion, that he was physically and financially able to do that, but he chose not to do that. Again, I would just ask the court to look back at the adjudication hearing in 2017 when he was in the perfect position to show reasonable progress, and he willfully continued to commit these crimes that led him, by the time of the determination, he was in lockdown. And it was all because of his conduct. So we would just ask the court to affirm the trial court's findings of fact and conclusions of law. And I will turn my time over to Mr. O'Rourke for the best interests, unless anyone has any questions.
Seeing that there are no questions, may it please the honorable court, my name is Reggie O'Rourke. I serve as associate counsel of the Guardian Litem program, and I represent the juveniles in this matter. I will be speaking with you about the dispositional arguments and issues, and if I have time, I hope to be able to touch some points on the grounds phase. Your honors, I hope to address 4 arguments regarding the best interest or dispositional phase. First, the standard of review. Next, I'll speak about the trial court's findings. Trial court made findings under 7B1110 that were supported by competent evidence and made written findings on all of those 7B1110 factors. Third, I will argue that the court was not required to consider other dispositional alternatives. And finally, I will hope to refute any arguments that the father that he was going to imminently complete his case plan. With respect to the abuse of discretion standard, Your Honor, it sounds like the mother's counsel has conceded that point. I know the father's counsel put that in his brief, but the standard of review is abuse of discretion, and this court has affirmed that many times in 2013 in LMT, 2016 DLW, and then recently in JJB, ZAM, ZLK, and AMO. Your Honors, I hope that you will find that the respondent mother's arguments in her brief were analogous to those in NRA AMO, where respondent mother in AMO limited herself to limit her arguments to the standard of review being de novo. And I believe that in the respondent mother's brief, she did the same, or the respondent mother did the same here, and provided no other alternative theory of the case. Your Honor, in AMO and our case law clearly holds that abuse of discretion is a deferential standard, where the court this court will reverse the child court's assessment of the best interests of the child only if that decision was manifestly unsupported by reason, or was so arbitrary that it could not have been the result of a reasoned decision. In the case at bar, Judge Bousman did make findings on all of the 7B 1110 factors and made a reasoned decision. Your Honor, I'll skip to my third argument in the interest of time, and just because I think it focuses more on the arguments that respondent mother focused on, and that's regard to other permanency options. The trial court was not obligated to consider other permanency options, and that holding was also affirmed in ZLW. In ZLW, the respondent father didn't contest any of the dispositional findings, but instead argued that because of the strong bond between him and his children, the court should pursue another form of legal permanence. This court rejected that argument and held that when it is not in the juvenile's best interest to return home, the juvenile will be placed in a safe and permanent home within a reasonable period of time. And in that holding, Your Honors, this court quoted 7B 100 and the purposes of the juvenile code. And so I ask that you find that same holding is applicable in this case. Your Honor, the trial court also found that on page 396 of the record that nothing in the termination of parental rights order precludes the relatives in this case from requesting that Wake County Human Services consider them for adoption. And the court also found that termination of parental rights order on page 396 of the record that it is not in the best interest to disrupt the bonds that the children have with the prospective adoptive parents in favor of relatives who declined the opportunity to provide the children a safe and appropriate home when they were asked to do so. I'll focus, that finding doesn't completely apply to the maternal grandmother, so I will focus on the maternal grandmother for a moment. The maternal grandmother, first I want to focus on Anne, because I think the issues with Anne and Mark and Gail are a little bit different. Anne has spent the entirety of her life with the person that she calls G-Mom. And we also know that that her G-Mom was the putative paternal grandmother up until Anne was 6 years old. And she treated her just like she was family before and after finding out that she was not biologically related. Anne's mother at the termination hearing on page 412 even said that Anne's G-Mom is like a second mom to her. There's testimony that Anne's G-Mom gives Anne opportunities to see extended family, including letting Anne go on entire weekend visits. So we have every indication that connection, although not a legal one, a relational one, will continue. And in the previous arguments, they've mentioned the relational matter, not the legal matter. And so we have every indication for Anne that relation with the mother and the mother side of the family will continue. With respect to Gail and Mark, the foster parents, there's testimony, and it's on page 393 of the transcript, that the GL volunteer testified that Gail and Mark's foster parents have stated on multiple occasions that they wish for the children to maintain contact with the biological family. And a testament to that is that Gail and Mark's foster parents even allowed their respondent father to call from prison. And of course, there was only 10 times that he called in the record, but that was due to him, not the foster parents. So there's evidence that the caretaker, that the prospective adoptive parents would continue to have that maintain that relationship with the biological family. With respect to the findings related to the maternal grandmother, I would dispute the fact that the court did not take into account any changes in circumstances, because the court actually, there was on page 81 of the record, in the TPR order, the court found that the maternal grandmother didn't have adequate finances or space to provide a stable home for the children, and that the mother actually lived in that home, also making it an inappropriate home. In addition, at the time of the filing of the termination hearing, we have ample testimony that that home was not owned and by the grandmother. There was no lawful reason for her to be able to stay there, and at any time she could lose the ability to stay there. She had not signed a lease for a new home. She had not moved, and ostensibly we need to ask ourselves, why hadn't she moved from February 2018 up to the months later, or 19 rather, to the point of at the point of the termination hearing? Why hadn't she moved? Why hadn't the parents filed a motion for permanency planning hearing to ask the court to award guardianship? So I'm going to move to the in the transcript. Actually, I'm going to move to the maternal great aunt. In the maternal great aunt, in February 28, 2018 order, there's a finding that the court found that it was contrary to Gail and Mark's best interest to be placed with maternal great aunt, since at the time the children had been in foster care for more than a year, and the children were thriving in their placements. That's on in the record on 216. With respect to the paternal grandparents, there's testimony actually by the father that his mother said that she could not care for the children, and then the father actually said from that point on he didn't want the paternal grandparents to have anything to do with the kids for an extended period of time. So this case is distinguishable from maybe other cases where we actually have a situation where we have caretakers or relatives and foster parents who are not only bonded with the kids, but who are integrating the family, who engage in shared parenting. I'm going to move to some of the findings of fact that are critical in this, and I'm going to start with the bond between the children and their parents. Starting there, that Anne has no bond with her father. It did say that Anne does have something of a bond with her mother, but it's more of a sisterly bond, and it's more of a peer relationship. And the court found that Anne's mother placed Anne in awkward, age-inappropriate situations. For example, asking her at least 2 times to give her urine samples for the mother's drug tests. The mother contacted Anne outside of the court's orders. That's in the record on page 395. And the court found that the mother does not appreciate the fact that she is demonstrating inappropriate behavior. I'm going to move with Gail and Mark. Mark does have a bond with his mother, but the court found on page 395 of the record, paragraph 74, that he considers his foster home to be his real home. Your Honor, in ZLW, this court held that the trial court is not obliged to privilege one of the best interest factor over another best interest factor. And in this case, the court weighed all the best interest factors and found that termination was in the children's best interests. And once again, the abuse of discretion is a deferential standard. The court's decision needs to be entirely without any sort of reasoning, and the court made very reasoned, very thoughtful, carefully considered findings of fact. I will just speak a little briefly about the likelihood of adoption is high in this case. It's uncontroverted that all 3 children are in pre-adoptive placements or prospective adoptive placements, and that the foster parents of each child are willing to adopt. The children are well bonded with the current foster parents, with their current placement providers, and Anne really has considered that is really Anne's home. Anne has spent more time there. In fact, in the record, it says that Anne spent 1 day with her maternal grandmother, and then I think it was for some reason maybe related to transportation with school, she left that home. So we're looking at, I think in some ways we can look at the children differently with respect to the placements that they're in, knowing that the children do have bonds with the current placement providers, and the current placement providers are going to continue to nurture the relationships with the biological family. So, Your Honor, is that at the end of my time, and thank you for letting me present the arguments for the Guardian Litem program.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I know we've got just a few less than a minute and a half. I'm going to go quickly, Mr. Ewing. If you've got something, maybe you'll have time to jump in. First, to Justice Earle's point, Stephen was not directly responsible for the activities that resulted in the petition, specifically the physical abuse of Mark and the neglect that occurred in the mother's home. Now, he stipulated to it. There was an adjudication. The adjudication is fair game. It can be considered, but the court has to consider, also the trial court had to consider what happened after that adjudication of neglect. And it is a relevant fact that he wasn't sort of directly responsible for the abuse. It happened while he was out of the home. The only offense that was charged was the violation of the cell phone, and that occurred 3 months after the petitions were filed. There were no other new offenses. There were infractions, and those infractions had the impact of cutting his earned credit time down, so he would serve his maximum as opposed to something less than the maximum time. But, the only offense was the cell phone offense. All of us here wish that Stephen would have been the model inmate. But the infractions that the court relied on here didn't really show that he would neglect the children, and they didn't show that he was unwilling to make the effort.
I'm sorry. I'm afraid your time's expired.
Thank you. We asked the court to reverse. Thank you.
Thank you to everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess until the next calling of the calendar. God save the state and this honorable court.